Okay, you will see up at the top left-hand corner of your screen an icon suggesting that, or announcing rather, that we are in fact now on YouTube live stream, and anyone who might have otherwise come to the courtroom is therefore invited to join us. And then I'll take it off of that before we finish. So we're here on Sanchez versus David. We've already entered your consolidated pretrial order. You are on our trial calendar for April the 4th. And I am prepared to take up anything you'd like to take up in preparation for that jury trial, and or I want to get to the motions in limine. So, Mr. Stokes, anything that we need to do before hearing the motions in limine?
Oh, Your Honor, just straightforward 2 motions in limine.
Okay.
Basic hearsay and expert testimony.
Okay. You have filed motions in limine? I've got the defendants. I'm not sure I had seen.
Yes, I did.
Okay. Well, let me run get those. And all right, Miss Salmons, anything we need to take up on your end before we start hearing the motions?
Yes, Your Honor. A few points, please.
Sure.
First of all, do you mind if I have my coffee with me? I know that's not usual in the courtroom.
Not only do I not mind, I heavily endorse it. And
Excellent.
Well, I'll join you. I'll join you.
Your Honor, I admit I have not tried a case during the pandemic yet. Are you allowing people, including jurors, into your courtroom? Are you still requiring it being virtual? I've had many colleagues and partners that have done trials virtually and candidly really didn't like them as far as being able to, assess jurors and see faces and things of that nature. And I frankly, just being gone as much as I have with my family issues, I'm sure you have it in writing somewhere and I haven't read it. And I certainly will, but just for this purpose, how are you doing your trials, your civil trials?
okay, first of all, that's a great question, and one that I wanted to address with y'all, and I actually think you're going to be pleased.
Okay.
What we're doing now is we do a voir dire via Zoom. And what that entails is that the 2 of you and your clients will physically come down to the courtroom 8A, and we have a huge monitor. Each counsel table has a monitor, and then there is a big monitor nearby. And beginning at 10 a.m., a panel of 12 will appear on the screen. Jury Services sets it all up. And I'm sitting where I always sit, court reporter sitting where she always sits, y'all are sitting where you always sit. The only difference in that very first day is that the jurors appear via Zoom. So there'll be 12 tiles. We work very carefully to make sure the screen's not real busy with a bunch of unnecessary tiles. They're each numbered by their corresponding juror number, and you have that information just like you always have. And there will be 36 of them from whom to get a jury. And the only difference, and the only thing that is kind of bad, not bad, but the only thing that is that we have to do the general questions 3 times. So panel 1 appears. I do my general questions, which are very short. You do your general questions, and then we do individual voir dire right then and there. I will allow you, and I make a big thing about it for the jurors, and so far there's not been a problem at all. I'll allow you to take a screenshot with your cell phone of the entire panel. And the reason for that is once we finish a panel, we're through with them. They go on about their business. In the meantime, panels 2 and 3 have been excused until we tell them to come back. So it's just like the courthouse. They stay connected, but we will tell panel 2 to be back at 11 or click on at 11. They do. We haven't had a problem in the world in the 5 or 6 jury trials we've had, civil. Do the same thing. Take a screenshot, let them go. Do the same thing with panel 3. So we should be through with voir dire, by lunchtime or shortly thereafter. Then they're gone. You strike in the courtroom, just like the old days. And then you're gone. You can leave. And we get the selected jurors to then physically come to the courthouse the next day. So we will start opening statement and we will start the trial, and they sit in the jury box, which they very much like, as opposed to we initially were doing these things with the jurors sitting socially distanced in the audience. This week, we eliminated social distancing, but we have elected to maintain masks. So the jury will be sitting in the jury box. They will have to keep their masks on. You can take your masks off unless you are approaching a witness or in any way kind of breaching that special place between where you're standing and the jury. We publish all documents on by use of Zoom screen share. So you're not going to be giving them a piece of paper. Like if you're going to do your text, you're going to have all of those digitized, but you need to bring a hard copy. So if you wanted to show the jury, if you get a text introduced and then you want to publish it to the jury, you don't do it by having them touch paper and hand it from juror to juror. You'll then use the screen share option to put it up on the big monitor. But you do have to have a hard copy for them to have at the end of the case back in the jury room. You're going to like it. I mean, it's just like normal, except from time to time you'll be wearing a mask. Except for voir dire, and candidly, I'm a recovering trial lawyer, and I like this voir dire better because you actually get a little bit better view of them. Their head's going to be about, this big instead of this big.
Right.
And you can take pictures of them. So when you're doing your strikes, you can remember who's who rather than having them sit out in the audience. And I didn't mean to talk so long, but do you have any other questions?
So just one more point of clarification, I think. So jury selection will be April 4th. It will go very smoothly, I'm quite sure. And then we leave the courtroom, midday, and we come back the 5th, the morning of the 5th.
Correct.
Okay.
And all your jurors will be there.
Okay. Well, Your Honor, other than many of my motions in limine are the standard ones, just to make sure that it's perfected for an appeal. But there are just a couple, 1, 2, 3 that I would like to argue. And then, of course, I've moved to bifurcate the trial because of an allegation of punitive damages. So we will need to be heard on that.
Okay. All right. Well, I tell you what, we'll do this the old-fashioned way. And Mr. Stokes, we'll take up your motions in limine.
Okay, my 2 motions. One is that to exclude hearsay statements concerning usually the quality of the painting job in this case, and as well as the testifying by lay witnesses who are not experts on painting. They're just 2 of them.
All right, would you like to respond, Ms. Sammons?
Your Honor, I don't anticipate that there will be any hearsay statements since it's going to be from the parties themselves. But Mr. and Mrs. David will be testifying, and there is one other neighbor witness, Mrs. Norwood, who witnessed. She's a next door neighbor, and I would be calling her as well. So I don't anticipate having a problem with hearsay, and I understand that hearsay is a no-no unless there's a valid exception to the rule. And if there is, I'll certainly allow him to object, and then I'll note my exception at trial. So I don't think that that's going to be a problem for anybody.
All right. Mr. Stokes, we'll take that up on a motion on a case-by-case basis. And I think we're all experienced enough to not only know it when we see it, but anticipate it when it's coming up. So that is denied, but certainly we will not allow any inadmissible evidence. Okay, your second one.
Well, the second one is they'll get some layman like Ms. Norwood. I don't know what she's going to testify to, but if she says that's a bad paint job or something, she's not qualified as an expert.
Okay, well, maybe that is something that we need to discuss, because aesthetics are, how is that confined to experts?
Your Honor, is that to me? Because I'm happy to respond.
No, that's to Mr. Stokes.
Okay.
Well,
You don't think the average person can look at a wall and say that looks bad?
well, that depends on what they say. If they say that there wasn't enough paint or something like that, I think that is subject expert. And I have used, for a number of years, I practiced construction law, and I always used an expert, and it was always an expert, which I usually use somebody at Georgia Tech, but it was always an expert on the quality of the paint job.
And do you have such an expert for this trial?
I don't know.
Okay. All right, Ms. Sammons, you want to respond to that?
Yes, Your Honor. Mr. Stokes is correct. I mean, neither one of us have an expert in this case, and I don't feel that it was required. This is a case where, obviously I could tell you've read everything, but he has pictures saying that everything was hunky-dory, and we have pictures and saying that it wasn't. And I think that the homeowners that caused this, this litigation and Mr. Sanchez are both going to be able to get up and have a picture and saying, this is a horrible paint job, and this is where my flower bed was destroyed. And I don't think that requires any sort of expert testimony. I don't think that Mr. Sanchez would have to have an expert for him to be able to say that he felt like he did an appropriate paint job. I think that it's fine for factual lay witnesses to make observances, for the homeowners to be able to say, this is what it looked like, and this is what he didn't do. That's a fact. That's not a standard of care type question. Nor would I ask Mr. or Mrs. David if they're French, by the way, Your Honor, just so you'll know. Nor would I ask them, to a reasonable degree of painting certainty questions, anything along those lines. I'm going to say, why were you upset with this? Was it performed? Was the contract met according to Mr. Sanchez's agreement with you? And we'll leave it at that. I think it's quite, I don't want to say simple, but basic, that it doesn't require any sort of expert testimony, which is why I think Mr. Stokes, if he actually felt that this was a professional care case, that he would have had an expert to defend his client. So I think that we're both on the same page on that.
Okay. Well, I think anything more on that, Mr.
No, Your Honor.
Stokes?
Oh, I'm
Or
sorry.
Mr. Stokes?
No, Your Honor.
Okay. I think that the issue is really one of opinion. I think what Mr. Stokes is trying to say is that, if someone is on the stand and says, well, this is just bad, anybody could tell it was bad. I think he's asking us to restrict the testimony to the actual five senses. And that's fine. I get that. And I get that no expert has been designated. but I'm not gonna stop somebody from saying, here's a photograph where you can see brush lines, or here's a photograph where you can see the paint, the existing paint showing through the coat over it. I mean, that's what this whole case is about, I'm assuming. And so that's denied. Okay, you ready to argue yours, Ms. Sammons?
Yes, Your Honor. With Mr. Stokes and Your Honor's permission, again, I'm kind of old school. Many of these motions in limine are the standard motions in limine that are routinely not objected to. So I would think, and Mr. Stokes is welcome to disagree with me, and then I'll go back.
Here's mine. 1 is okay.
Correct.
3 is okay. 4 is okay. 8 maybe. And the rest are no. And I'll hear from you on the no ones, which are 2, 5, 6, 7, and 9, and 10, and 11. And I just want you to concentrate on what a motion in limine is. It's a shot between the eyes saying it's excluded. There may, I mean, all of these may have, objections, but let's start with number 2. I hear insurance, but why do you care who paid?
Hold on 1 second, Your Honor. I'm making my notes on your okays real quick.
Okay is number 1, 3,
Okay.
4, 8 is a maybe. And then everything else I have is no.
Okay.
So on number 2, any evidence or argument regarding payments from any outside source. Who?
Your Honor, I withdraw it.
Okay. All right. Now on number 4, no,
I have an
number
okay.
5. Yeah, number 5, special damages. What's
Correct.
that about?
Your Honor, when Mr. Stokes and I have been speaking to each other over the course of this litigation, and again, both of you have been very cooperative with my situation, but he's in our settlement discussions. I'm not speaking about money, but in our settlement discussions, he's consistently said that somehow Mr. Sanchez was put out of business and was unable to obtain another job. That's in his factual statement in the pretrial order, but there's absolutely no evidence whatsoever that in fact has occurred. I haven't seen anything, and I've asked for that. I've said, I can't even locate your Mr. Sanchez. Apparently he's somewhere, but I have no evidence, no documentation, no proof that anything actually was incurred by him from a loss of revenue standpoint. And if he has it, then I suppose I would have seen it by now, because that certainly would have helped in our discussions. But I haven't seen anything. And in my investigation, through social media, private investigators, this, that, and the other, that there isn't any. So I don't think that it is appropriate for Mr. Stokes to be able to argue any sort of special damages for Mr. Sanchez after this particular job went south, if there's nothing else there to prove it. And that's the subject of that motion.
Okay, so is this you're suggesting that he might talk about special damages in terms of the slander and the libel?
Right. I mean, he claims that what my clients allegedly did to him resulted in his inability to be able to get work and his inability to have a quote unquote positive reputation in the community. But there's absolutely, thus far, no evidence that actually occurred. So when you're going with my defense of the truth, which is an affirmative defense, and you conclude that there was no special damages to Mr. Sanchez, then, frankly, case over. So I don't think that he can come in now with the pretrial order being signed, the discovery period being expired, and somehow come up with something to suggest that there are in fact special damages in the case, because there's nothing there. And it wasn't even pled in the pretrial order, and Your Honor has signed it. So absent submitting and pleading special damages as required by the Georgia Civil Practice Act, I think that now should be properly excluded.
Okay, Mr. Stokes?
Your Honor, this is a libel and slander per se. And as I showed in the pretrial, that the damages can be inferred and they can be proven. I intend to prove it by Mr. Sanchez simply testifying that he couldn't get any jobs in his typical market area because of the horrendous slanderous situations that occurred by the defendants. And he's going to testify to that. And he's going to testify to what his annual income would have been. Then he had to go to work for other people.
And what are you going to ask the jury to do? Maybe
I'm going to ask the jury to get for a verdict in accordance with the OCGA on libel and slander, for a verdict for the damages, compensatory damages.
All right, and what are, I mean, I somewhat see Ms. Salmon's point. I mean, when I think of special damages, I'm thinking of special interrogatories to the jury and so forth. And I'm just wondering what those are. If you're saying, well, as long as they find $1 or whatever the law is, they can give whatever is in their enlightened conscience. I mean, help me out here.
Well,
Maybe I'm getting hung up in the term special.
I don't think it's special. I think it's general. It as provided in the two codes that the jury can infer the damages. The jury can find for the damages without being specific. For example, he's going to say that he was put out of business and that he would have earned during that period of time on a normal year such and such. It's like $90,000 to $100,000. And this is the gravamen of the entire case. Your Honor said that in the earlier part of this hearing, there was a discussion concerning whether the painting was appropriate or not, and I submit that that's not the main issue. The main issue is the libel and slander that put him out of business.
Okay, well, let me just put it this way. Does anybody have a case or a statute that says that damages on a libel claim or slander claim or defamation claim are equal special damages?
Your Honor, I'm happy to research that more particular issue, and if I may respond a little bit.
Sure.
With all due respect to Mr. Stokes, certainly, and Mr. Sanchez, whom I've never met, if he gets up on the stand and says, this is what I would have made, or this is what I lost, where is that evidence? I mean, there's no information other than pure speculation, as best I could tell so far, from Mr. Stokes or Mr. Sanchez as to what happened. So that's the point of my motion in limine. I don't think that—
Isn't that what cross-examination is for? Isn't that what the jury is for? If he gets up there and says, well, I just lost my business, and then you pick him apart, corpuscle by corpuscle, on who have you brought in here? What's your checking account say? Where's your income tax return? What do you mean you've lost business? I mean, I would think that would be fun.
Yes, ma'am. Yes, ma'am, it will, Your Honor. And I will do that. But I still submit that if he is saying that Mr. and Mrs. David libeled and slandered him, that's one thing. If he is saying that Mr. and Mrs. David libeled and slandered him and caused him to be unable to make money and get jobs without any proof, I believe under the law that those would be considered special damages, blackboard special damages, and none of that information, evidence, documentation, not a shred of paper has been provided to prove those special damages up to and including today.
Okay, I'm going to take number 5 under advisement. If you do find any case law or statutory law, right now it sounds like what he's talking about is compensatory, and I'm going to put it under my basic. Again, this is a motion in limine. My basic feeling is that would be denied, but I'm going to take it under advisement. Okay, number 6, irrelevant evidence of general character. We don't let that in, but I mean, again, this is a motion in limine.
Correct. And Judge, it may just be the way that I've practiced for the last 20 years that you do things differently since I've never been in your courtroom. To me, that is a standard motion in limine, just to cover my basis in the event that it did go in somehow, and that it would be an appealable error that I would have available.
Okay, so I'm going to deny it as a in limine, and we're going to take it up on a case by case basis.
Okay.
And then we'll talk at the end about opening statement. Okay, how about number 7, bolstering?
7 it's the same as 6, Your Honor. It's I know that it cannot be done, so I've put it in my general list of motions in limine that I routinely file if I'm going to try a case for appellate error.
Okay, there are, of course, under the evidence code, there are statutes with regard to rehabilitation. That's not what it's called, but after impeachment.
Sure, I'll follow you.
And so I'm going to deny that and take that on a case by case basis. Okay, now number 8, I had maybe. Defendants move to exclude any argument or allegation. Oh, this is golden rule, right?
Yes, Your Honor.
Okay, I'll grant golden
Yes,
rule.
Your Honor. Thank
You want to talk, if Mr. Stokes, anytime you want to talk, interrupt the women.
Well, I learned a long time ago not to do that.
Well, you're invited to. Okay, number 9.
When the revolution comes, I expect to be spared.
No, we'll come get you and protect you. Okay, number 9, Ms. Salmons, I think is going to be sort of the first cousin of 5, which
That's
I think
absolutely correct.
Which I think I am going to take under advisement, pending any research you submit. Number 10 is no. So on this one, this is excluding testimony about the motions in limine, which I think you mean you don't want him saying, well, they tried to exclude this, so you wouldn't even hear it. You mean that kind of thing?
Correct, Your Honor. And I've had that occur in one case in the past. And again, just to let Your Honor know, my number 10 isn't highlighted. It's just that I always file it because I've had counsel get up and say, well, Mrs. Salmons has already tried to do this and the judges denied it, behind your back in a previous proceeding. And jurors are like, they don't understand that legal proceedings are legal proceedings and judges are going to make their decisions. But jurors respond to it, to me, in my opinion, with a look of surprise. So it's a formality, just saying, don't get up there and say what we've discussed in a pretrial hearing. We know what we can and cannot say once we get in front of a jury, and leave it at that.
Mr. Stokes, you response?
I'm not going to do that.
I'm going to change my no to grant, just as in keeping with in limine. Now there is a statute that says if the other side doesn't produce evidence on a point, there's a presumption that Well, you know, that has more to do, though, I think, with discovery. I think that what I'm hearing generally is that you don't want either of you to say, you know, they tried to hide this from you and the judge let them.
That's right.
I think we don't, either one of you do that. So I will grant that. Number 11. Now, this one is really interesting. I'm take it away, Miss Salmons.
Yeah, this one to me, Your Honor, is as a matter of law. When I was going through the pretrial order, and again, Mr. Stokes and I have gotten along very well. And just for the record, on number 10, I never would expect him to do that, but sometimes lawyers do things that surprise you, and you're like, wow. But with number 11, for the first time, I saw a new allegation brought by the plaintiff entitled theft by extortion. That was never pled in the complaint. It was never brought to my attention prior to the pretrial order. It's a brand new allegation that was put in the pretrial order at that time. And as I read the law, and I did do significant research on it, that has to be dismissed as a matter of law, because I've never had the opportunity in any way up until the pretrial order was drafted to investigate, do discovery on that allegation if I had wished to. And it's a fairly serious allegation that's been made. And according to the law, it's barred as a matter of law. And the entire time that we've been handling this case, this has been a libel and a slander case. He said libel per se, slander per se. I've said truth. And that has been it. I don't want to say that it's vanilla, but it is certainly clear cut. And then once I get a pretrial where there's a third allegation that is very serious allegation, I move to dismiss it as a matter of law as being untimely and not being able to give me any way to defend my clients against this particular cause of action. Was news to me.
Mr. Stokes?
Your Honor, that's actually in a separate count in the complaint, where it was under the emotional infliction of emotional distress, specifically cite that statute in the complaint. That it was an extortion. Sometimes it's referred to as compounding a felony, but that's been in the complaint since day one.
Your Honor, if you'll give me one moment,
Sure.
If it was.
Well, it's in the pretrial order, which of course supersedes the pleadings, but
one moment, Your Honor, I am flipping.
okay.
Because I want to make sure that I am correct.
I mean, I know the concept of, we're going to call the police.
Your Honor, it says slander per se, libel per se, and intentional infliction of emotional distress. To me, this is a very explicit allegation, theft by extortion, and I don't see it in the complaint. And I think
it is in paragraph 23
as a separate allegation.
It's under intentional infliction of emotional distress, paragraph 23. He says, by threatening criminal charges against plaintiff and his family if he did not pay them back the $9,000 paid to him, which amounts to extortion in violation of 16-8-16.
So he's
and then, of course, it is in the pretrial.
Well, he cited, he cited the statute, Your Honor, but there's no written allegation of theft by extortion. I was under the impression that it was an intentional infliction of emotional distress claim, which is completely different than theft by extortion. I would move to dismiss that allegation, Your
Honor. Okay, so again, the intentional infliction, and Mr. Stokes, I don't want to do your work for you because you're smarter than I am, but the intentional infliction of emotional distress arises out of the criminal statute. I mean, I think Ms. Hammond's point is pretty well taken, that the plaintiff as an individual does not have the standing to enforce the criminal laws of the state. And obviously that's something that we're all, there's hundreds of cases on that. And yet, I think I guess what he's trying to say is their criminal behavior hurt the plaintiff? Mr. Stokes, what's your point here?
Well, the conduct caused him emotional distress. We're not saying that we're sort of bringing any action on the criminal nature. We're saying this is criminal conduct.
Yeah, but it hasn't been adjudicated criminal conduct by any criminal action.
Well,
I mean, I think the issue is, and again, I'm sorry, I'm doing all the talking, but I think the issue is, can a citizen seek civil damages for the violation of a crime? I mean, for the violation of the penal statutes. And I'm going to take it under advisement, and let's see if we can get some law on that.
all right.
Okay.
Okay.
Sure.
Okay.
Your Honor, just may I briefly?
Sure.
And I will look for some more case law on that. But I understand that Mr. Stokes is going to argue that his client suffered emotional distress. I understand that from a civil perspective.
Mhm.
But just I know we don't have a court reporter, but just for you, the record for you, Your Honor, I think you've nailed it right on the head. I mean, this statute that he then expressly cited in the pretrial order suggests that my clients are having to somehow now defend themselves from being accused of a crime. And that's a whole different ballgame than a civil lawsuit where a person says they've been emotionally distressed by someone's civil conduct. And that's why I believe that, this particular cause of action, I'm not suggesting that I'm asking you to dismiss an IIED claim. I'm suggesting that this particular statute and anything associated with speaking about that to a jury is barred as a matter of law. IIED, civil IIED is different, but getting up and telling a jury and saying crime and criminal accusations is a whole different ballgame than saying my client was emotionally distressed because of my defendant's conduct.
Their criminal behavior.
Correct.
This might, and y'all just think about this might be cured by a reference to the word extortion rather than the citing of the statute. They essentially try, I think jurors understand bribery, they understand extortion, they understand the concept that Mr. Stokes is saying, we'll do this if you do that. Just think about that, because I think that's what he's saying is they were, they threatened.
That's precisely what I'm saying.
Without necessarily, which is a crime under 16 dash, because at that point, if that were to come out accidentally, I would let Ms. Salmons put on 2 days worth of testimony that the district attorney had never been presented any case, that they'd never pursued any case, that no such, we all hear perjury bandied about, and from time to time you'll read an article that there's been no perjury charge brought in 159 Georgia counties in the last 25 years. I think, I don't want to have Fonnie Willis on the stand testifying this is absurd. We don't put homeowners in jail for threatening painters.
Right.
And I think you get your point across with, it's not nice to threaten people. I'm just thinking there may be some pretty easy fix here.
Your Honor, let me do a little bit of research.
Okay.
And then Mr. Stokes and I will certainly talk about that and see if we can come up with an agreement amongst ourselves as to what we, frankly, what I would accept that he would say and what I wouldn't. And if we can't come to an agreement, we'll get back in front of you in some shape or fashion.
Okay.
We've never had any trouble getting an agreement with Ms. Salmons.
Well, let me just say this. Let me say what you expect to hear from me, which is, guys, come on. I have always just thought you had 3 mad clients, and that there was nothing that great lawyers can do with 3 mad people. Do you want me to talk to them? Do you want, I'm assuming y'all have tried mediation.
If Your Honor, and Neil, just speak up if you wish. We have not attempted a mediation. Candidly, we're dealing with 2 homeowners here, and one, I agree with you. We have 3 upset parties where things went wrong. My clients are just as mad as Mr. Sanchez is.
Yeah.
They absolutely are. And it's kind of like the way they tell me, and I've thought about it a lot, it's like a Yelp review. You hire somebody to do something, or you go in some fancy restaurant and you get horrifying service or a rude waiter or something along those lines. And the person instantly, I've never done it, I'm too old, don't know how, but the person instantly jumps up on Yelp and says some scathing, nasty review. Well, that's true. It's true. And that is the purpose of some of these sites. So, for example, the neighborhood association, it's absolutely, my defense is that it is true and that they are able to say that. Now, Mr. Sanchez believes that they weren't allowed to say that, but you're correct. That's what's going on here. We had tried, I believe, or I'll speak for myself, I tried to settle with Mr. Stokes, and frankly, we haven't reached a complete failure to settle yet without mediation because of the cost. And I know that Mr. Stokes is on a contingency with Mr. Sanchez. Well, I can't imagine that he isn't. My clients are paying me by the hour. There's nobody behind them, so I'm like, we don't need to go spend $3,000 to see if we can get this done with. Given that Mr. Sanchez, in my opinion, got all of that money and did not complete the work, I have been attempted to settle with Mr. Stokes, and I have made an offer, and he has reduced his demand, but we're significantly apart.
How far apart?
What do you think, McNeil?
This is what juries are for.
Yeah, I'm at 90,000 and she's at 15,000. She came up and I suggested maybe, she could come up to, with 10,000. I could come down 10,000. I think we might get there, Judge.
Now
the problem is that I don't think there's any insurance.
You're going to have to get a jury. Let me ask you this, because you said something very interesting, Ms. Salmons, is that I did not know. Your clients are French.
Let me be very clear, since we're just speaking pretty candidly. Mrs. David is not. She is American. So I apologize for that. Jean-Noel David is not American. He has an accent.
Does he speak with an accent?
Yes.
Because I always thought that Mr. Stokes' strong suit was that here are these rich people threatening this poor old guy who's trying to make a living painting. And if that's taken away in any sense, Mr. Stokes, by this being another immigrant who has pursued the American dream, that would trouble me.
Your Honor, he's a citizen. He's been a citizen for 25 years.
And I'm proud of him.
Right.
But
But your
that was
story,
my whole point, is that, you're threatening this guy who's done everything we asked him to do. To be a vital part of our economy. But
right.
if the suggestion as to immigration is lingering as I thought it was, now you may take that sting away in front of the jury by saying, well, here's somebody who made it.
That's right, Judge. And you kind of hit it. That is his past. He is a citizen now, but I'm certainly going to bring up his background and how hard he's worked and things of that nature.
90 is too high, Mr. Stokes. Who made the last offer?
Mr. Stokes, over the phone, I called him. Gosh.
Oh, it's your turn to respond, Ms. Simmons. What's your best number?
Well, that's a little difficult to answer that question, and I'll tell you why. This is going to come straight out of their pocket. That would mean that they don't get their $9,000 back. They've had to repaint all that stuff to get this in order. We do have money. We have more money than that, but I didn't get upset with Mr. Stokes, but I got frustrated when we've only gotten to 90. I mean, if we get down to half that, then I will tell my client, you need to go get a loan if you have to, and we get this done so that we don't try it and you keep incurring legal fees and this, that, and the other. But I just feel silly responding to.
You can't do it against yourself. So would your clients walk away from 50, Mr. Stokes?
No.
I mean, would your client walk away from, leave 50 on the table?
No, 50 would be fine. That's what I thought we were. That's what I thought we probably were going towards, but without we just didn't get back in touch with each other.
I candidly, my client works 24/7 out of town. So he is on a plane right now. His wife, Stacy, has not felt very well for a long time. She has lots of medical issues. So I haven't really been speaking with her as much as I've been speaking with Jean Noel. So I will report to him if I'm given permission by McNeil of a demand of 50, but I can tell you that is really still very high.
Now, Ms. Simmons, I threatened Mr. Stokes to get him down to that. I think now you need to explore. I think you need to tell Mr. David, I'm not going to tell you, you're better lawyer than I ever thought about being, but I think that he's got to be reminded that a jury's just going to do what a jury's going to. I mean, I can limit the damages. I can call him a duck. I can do all these things. And at the end of the day, 12 people are going to go in a room and go, damn, I wouldn't want to be treated this way. And then does punitive ever raise its ugly head again? And I will bifurcate in terms of, it's not all good. You're going to give all your evidence, but the question is just going to be, are punitives warranted? Then we'll send them back out. If they come back and say yes, we'll send them back out to determine any amount. So I'll bifurcate to that extent. I'm not going to have 2 whole trials. You see what I'm saying? Yes. So he would argue that their behavior's been horrible. They've been ugly and rude. And then the verdict form would say, are they entitled to punitive damages? And my charge would be, now punitive damages are only under certain circumstances. And then they'd say yes or no. Then you'd go back and argue to them, well, if you've said yes, my client needs $200,000, which I think y'all can correct me. Does some of that go to the state?
It does. There's a cap, but
Who
well,
wants that?
no,
So, I
There's a-
mean, I think you need to be, don't take away the fact that Mr. Stokes might be able to come way down by saying, well, no, now my mouse has gotten out of the trap. He wants to come back for the cheese.
understood, Your Honor. I understand.
Because boy, y'all would be saving yourselves a world of hurt. There's nothing fun about a jury trial, and I can use that jury for us and get somebody off the street.
I understand, Judge. I mean, I do, and I want to get the case settled. I mean, you know, again, candidly, and I know we're probably going over your time, Your Honor. You know, this is devastated them as well, and you know, the cost associated.
How
with
about
it.
X amount of money and they say they're sorry?
I have no problem with that.
Well, in a settlement, let's talk about the $50,000 figure. That's a compromise figure. Why don't Ms. Salmon see if that's acceptable? Otherwise, they're facing, could be some very steep damages. And as everything I know about Mr. David, he's a hardworking guy too. And if we could settle this thing without potentially bankrupting him, and apparently there isn't any insurance on this case, then I'm not trying to get a pound of
For
flesh.
slander? I haven't met an
No.
insurance company that insures for slander.
No, this is just them. And McNeil, Mr. Stokes, I'm sorry. But let me ask you something. You know, if you guys really want me to try to hard sell this and cause them financial hardship, candidly, and I understand the risk, but I also understand that I don't see any evidence at all, that Mr. Sanchez did in fact suffer damages.
Don't argue the case anymore. We
No,
got
I'm
you half.
I'm not, Judge. I'm not.
We got you down to half.
I'm not, Judge. What I'm asking is, Mr. Stokes, if you can get me something in settlement discussions, we're not doing this in front of the judge, but if you can get me something where I can tell them, look, this is what happened, that would also help. It's difficult for me to get to a number like that when they believe, one, that it's true, and then two, that he didn't get damaged. It's just difficult for.
Before you answer that, Mr. Stokes, I do think, and I humbly suggest that you do tell them that the judge said, settle this case, and that's not an unreasonable amount. I just tell you, juries, I have never, not once, ever in my humble experience, had a jury get it wrong on criminal. I've had tons of acquittals and I understood where they came from. And I've had tons of convictions and I sure understood where they came from. I've never seen a jury get it wrong.
Right.
On civil,
Yeah.
you know, you get whether you end up with people who generally are doing their jobs and they're very conscientious about jury duty, but they're coming downtown when they're not really sure where everybody's been. And, you know, they're compelled to leave their homes and families and businesses. A lot of them, boy, you will hear, I hadn't had a job for 2 years and I just got a job and you want me to come do what?
Right. Yep. I know. I've seen it. I understand exactly what you're saying.
And I think the DeVides need a little come to Jesus, which I'm happy to, and I didn't mean to be sacrilegious. I'm happy to get on a call. Frankly, people usually just get so annoyed with me, they settle.
Well, Judge, I mean, I welcome that. Like I said, I promise you, he is on a plane right now.
Okay.
So I'm not able to communicate to him until he gets somewhere where he can call me. But I will communicate all of this information and the substance of this hearing. And I will even tell him that you have welcomed a phone call with him. Candidly, it would be probably just with him. Mrs. David is so upset about this situation with Mr. Sanchez. It would not be productive. I can promise you that. But Mr. David is a little bit more level-headed. So let me see what I can do and see if he actually reaches me and things of that nature. And I'll report to Jessica, copy everybody except you, and she can communicate that to you.
Okay,
Does that
that
work?
sounds great. And obviously the case behind y'all would be beholden with as much notice as possible.
Sure.
Your Honor, I had a couple of questions concerning that point. And are we the first out or the
I
case?
think
in front of
so. I think so. I can find that out for you.
Okay. Secondly, my daughter is my youngest daughter is a third year student at University of Georgia Law School, and I'd like for her to sit at the desk or the table with me. Is there any rules against? Is there any problem with
I
that?
would think that is, we have hereby deemed her your paralegal, and she's welcomed in front of the bar.
Yeah. Well, she'll be a lawyer in 2 months, in a couple of months.
That's
She's
wonderful.
going to be, believe it or not, she'll be the 9th straight generation attorney in our family.
That's outstanding.
So traditionally, we've always tried the first case with the new lawyers, with the old lawyer like me.
And I guarantee you, you will appreciate having her when I tell you to hit the screen share button on Zoom, because I'm not sure I can do it.
I'm sorry, I didn't hear you.
Now, I said, I guarantee you will enjoy having a younger person sitting at the table with you when I tell you to hit the screen share button.
Absolutely. I need a millennial to help me out.
We all need a 6-year-old.
Agreed.
Technology.
I've always had an assistant who is usually at University of Georgia, so
I got another Zoom
I
call.
need to team up with a millennial.
Yeah.
Okay,
Okay.
Judge, I'll be back in touch with McNeil and Jessica.
Sure. And
Okay.
I think we might, but please, I think we might be able to work it out if you can. And I'd give him if he needs an extra month or so to time or something, we'd get that to come up.
No, guys, but I appreciate your asking. Okay, go
Thank
be
you.
fruitful. Ms. Hammonds, again, my sincerest condolences about your mom.